Are we truly independent contractors? Or should we legally be treated as employees? This question shapes our paychecks, benefits, and protections. Too many employers misclassify workers using the contractor label to cut costs and deny overtime, unemployment, or insurance. But the truth is simple: the law decides, not the company. In today's video, we'll break this down together. Here's what we'll cover. 1. The laws that define contractor versus employee status. 2. The factors courts and agencies use to make the call. 3. Real-world examples where workers fought misclassification. 4. Practical steps we can take if we suspect our status is wrong. By the end, we'll know how to spot the difference and how to act if an employer crosses the line. Let's get started, because understanding this could mean thousands of dollars and vital protections for working people like us. Part 1. The law behind classification. We begin with the foundation, the Fair Labor Standards Act, FLSA. This law sets minimum wage, overtime pay, and child labor protections. But here's the catch. These rights apply only to employees, not to independent contractors. When companies misclassify workers, they try to bypass the FLSA and shift costs onto the very people doing the work. The Department of Labor and the courts don't simply accept an employer's label. Instead, they apply the economic reality test. Are we truly running independent businesses, or are we economically dependent on the company? A few signs help answer that. If we rely on one company for full-time work, that leans toward employee. If the company dictates where, when, and how tasks must be done, that leans toward employee. If we invest in our own equipment, set our own schedules, and juggle multiple clients, that leans, yes, toward contractor. The IRS also applies a 3-part test: behavioral control, financial control, and the relationship of the parties. For example, if the company gives detailed instructions about how to do the job, that's behavioral control, strongly suggesting employee status. Why does this matter? Because employers save money by shifting tax obligations, Social Security contributions, and benefit costs onto workers. Congress built the FLSA to protect against such abuse. The Department of Labor has pursued countless cases where businesses tried to stretch the contractor label too far. Take, for instance, a staffing agency that requires workers to clock in at a specific time, follow company procedures, and accept penalties for lateness. Even if the paperwork calls them contractors, the economic reality points to employment. So the main lesson from Part 1 is clear. The law looks at facts, not titles. Contracts, job postings, or independent contractor agreements don't override legal definitions. When our work reflects dependence on a company, the law leans toward employee status, with all the protections that follow. Part 2. The key factors courts use. Next, let's walk through the 6-factor test the Department of Labor reaffirmed in 2024 to clarify classification. These are weighed together, not in isolation. 1. Opportunity for profit or loss. True contractors have business initiative. If we can set rates, hire helpers, or negotiate contracts, that's independence. If pay is fixed regardless of skill or decision-making, that's employment. 2. Investments. Contractors usually supply major tools or equipment. Think trucks, heavy machinery, or office systems. If the company provides everything from uniforms to laptops, it points to employee. 3rd degree of permanence. Contractors often work short-term or project by project. If the relationship is indefinite, lasting months or years with consistent hours, that looks like employment. 4. Control. The more control the company has over how, when, and where work happens, the stronger the employee argument. If we control our own schedules and methods, we lean contractor. Fifth, integral work. If the job we perform is central to the company's main business, courts usually say employee. For instance, package delivery is integral to a delivery company, not side work. 6. Skill and initiative. Specialized trades that operate independently, lean contractor. But if a company trains workers and sets strict procedures, the balance tips toward employee. Example, consider John, who installs cable for a telecom provider. He wears the company's shirt, drives its van, follows routes set by dispatch, and can't subcontract. Even though his contract says independent contractor, every factor leans employee. Courts weigh all 6 factors, but dependence is the central theme. If the company holds the power and we rely on them for our livelihood, the law favors employee status. Understanding these factors equips us to analyze our own situations. The goal is not to memorize legal language, but to see how the law interprets reality. When most factors point toward control and dependence, we're likely employees, and we're owed the protections that come with that. Part 3. Real-world examples of misclassification. Let's see how this plays out in real life. FedEx ground drivers. For years, FedEx insisted drivers were independent contractors. Drivers had to buy or lease trucks, but they wore FedEx uniforms, delivered FedEx packages, and followed company schedules. Courts found that despite truck ownership, the drivers operated under FedEx's control, making them employees. FedEx ultimately paid large settlements for back wages and benefits. Construction workers. On job sites, many workers are labeled contractors. Yet if a general contractor dictates hours, supervises tasks, and supplies tools, courts often rule that these workers are employees. Misclassification in construction remains widespread, costing workers overtime pay and protections. Gig economy workers. Uber, Lyft, and app-based platforms often call drivers contractors. But under California's AB 5 law, workers are presumed employees unless the company proves A. The worker is free from control, B. The work is outside the company's usual business, and C. The worker runs an independent trade. Driving passengers is Uber's core business, so under AB 5, many drivers qualify as employees. Legal battles continue, but the principle is clear. Control plus core business equals employee. Other industries. In janitorial services, cleaning crews may be told they're independent, yet they wear company badges, use employer-supplied supplies, and work under strict schedules. Courts repeatedly side with the workers. Data supports this trend. The Department of Labor has found misclassification rates as high as 30% in some audits. That means millions of workers lose overtime, unemployment insurance, or workers' comp. Employers also gain unfair competitive advantages by slashing labor costs at workers' expense. These examples remind us, if our daily reality looks like employee work, uniforms, schedules, direct oversight, the law often agrees, regardless of what the contract says. Part 4. What we can do if we suspect misclassification. So, what steps can we take if we think our job title doesn't reflect reality? 1. Collect evidence. Keep records of schedules, emails, training instructions, pay methods, and whether outside work is restricted. The more details we have, the stronger the case. 2. Use official channels. The U.S. Department of Labor's Wage and Hour Division investigates misclassification. Filing a complaint can lead to back wages, penalties for the employer, and corrected status. 3rd, check state law. States like California, Massachusetts, and New Jersey have stricter standards than federal law. Even if federal classification is uncertain, state law may guarantee employee rights. 4. Consult legal help. Employment attorneys often take these cases on contingency. If misclassification has cost us overtime, health benefits, or unemployment eligibility, damages can be significant. 5. Speak up. Sometimes employers misclassify out of misunderstanding. Asking directly, "Am I considered an employee for wage purposes under the FLSA?" can open dialogue. If the company resists, that resistance itself is telling. Workers should not fear retaliation. Both federal and state laws protect against punishment for raising classification questions. Retaliation can lead to additional damages for the employer. The path forward is about asserting rights confidently and understanding the law. Misclassification isn't just a paperwork issue, it's about fair pay and protection for the labor we provide. Let's wrap this up. Whether we're contractors or employees isn't defined by paperwork, it's defined by the reality of how we work. The FLSA, the Department of Labor's tests, and state laws all ask the same question. Are we running independent businesses, or are we under the company's control? If we work with company tools on company schedules, performing the company's core services, we're very likely employees. That means rights to overtime, unemployment, and benefits. Misclassification takes away protections we've earned. But when we know the law, we gain the power to challenge unfair practices. If this breakdown helped, share it with others who might face the same issue. Stay informed, stay connected, and let's keep protecting our rights together.